or good afternoon if you are in Asia, and good very early morning if you are in Americas. This is our last event of the season, devoted to costs, damages, and duration in investor-state dispute settlement. Although I would really wish to welcome you all in flesh at Allen Overy offices here in London or in Hong Kong, but for the reasons we are all aware of, we're doing it in the online format, which actually has its own advantages, because we are able to attract speakers and attendees from jurisdictions which are very far from London. So it's quite unusual that our list of participants today includes people from Australia, from Korea, from Japan, from India. So normally we only pick people from London for our offline events. Sometimes we have guests from the mainland Europe. And I think this makes it, well, at least compensates to some extent the lack of normal offline interaction. So this event will launch our study on costs in cost duration and damages in investor-state dispute settlement. But let me say a few words about the logistics of this event. So we'll have I will introduce the chair, and then the chair will take over the meeting. After our presentations and discussants' reactions, we will open the floor to a Q&A session. You will be able to ask your questions by raising your virtual hand or by typing your question first in the chat box. We certainly welcome your questions and hope that there will be a very interesting discussion. We will record the presentations and the reactions, but we will not record the Q&A session, because we want everybody to be as candid as possible, and being not on record is one of ways to achieve it. I welcome our ITF members and guests, and I also remind you that if you are representing a government and you have not yet joined ITF, we are now offering free ITF membership to governments, because I think that government participation of states in our events makes them much more interesting. So let me know if you are interested to do that. We hope that in September we will organize an offline event. Actually, it will be a blended event. Probably we'll have an online component and an offline component here in London, but for now it's only an online format. And let me now introduce the chair of the panel, Anna Joubin-Bret, who is the secretary of the United Nations Commission on International Trade Law, also known as UNCITRAL, and director of the Division on International Trade Law in the Office of Legal Affairs of the United Nations. She has been in this position since 2017, and prior to her appointment, Anna was a practicing attorney at law at the Paris Bar. She specialized in international investment law and investment dispute settlement, and she worked as counsel, as arbitrator, mediator, and conciliator in international investment disputes. Also, she served as arbitrator in several Oecd, UNCITRAL, and ICC disputes. For 15 years, Anna was the senior legal advisor for the United Nations Conference on Trade and Development, also known as UNCTAD, and in this capacity, she managed the research and advisory work on international investment law issues, as well as the technical assistance program on international investment agreements. And Anna also was appointed as judge at the commercial court in France. And she was also elected as regional councillor in Rhône-Alpes region in 1998. Very interesting biography. And Anna, we are very happy to have you with us here. So now the event is yours.
Thank you very much, Yarik. And let me at the outset thank the organizers for asking me to chair this very exciting launching of a study that is now in its third edition. It's a very interesting empirical study that was first prepared and launched in 2013 which then followed by a second edition in 2017. And we're looking at the third edition now. And I find this particularly important because it gives us a possibility to look at trends. And in the area that we are looking into, which is investor-state dispute settlement, this approach over time is extremely important because we are currently, and that's actually the reason why I've been invited to chair this session. We're currently in UNCITRAL proceeding with a very in-depth work on reforming investor-to-state dispute settlement. And this mandate was given to the UNCITRAL Commission by the UNCITRAL Commission to its working group 3 in 2017. And it proceeded in three steps. The first step was to identify the main issues and concerns with investor-state dispute settlement. And not surprisingly, costs and duration were one among the three main headings under which we then grouped the various concerns as they were expressed, and as they were expressed not only by respondent states, but also by investors. And indeed, issues of cost and duration are the ones where there is great consensus that something needs to be done. And in order to carry out this work, it's extremely important for us in the working group, and of course in the Secretariat as well, where we work on the basis of where we prepare the working documents that are then being discussed and deliberated upon by the working group. In this working group and in the Secretariat, it's very important that we can rely on empirical data. And that's precisely what this study brings to the debate. It's empirical data. There is always, in most of the topics that we're discussing, there is always someone who will raise, or some delegation who will raise the issue that, oh, and by the way, do we know whether there is any empirical data that shows that this is really an issue? And I think what this study, and particularly the analysis over time, the trend aspect of this study, will allow us to discuss today. And I'm very grateful and glad to be asked to introduce the presentation, the launching of this study. This will be done by the authors, and particularly by our our team of authors that have joined forces over the years. Matthew Hodgson, who is with Allen Overy in Hong Kong, and who had started and began this research years ago. And I recall telling Matthew on several occasions that I found his work and his research so very useful to the practitioners, to the academics, and now in this new capacity where I am in UNCITRAL, to the entire working group. It's extremely important to be able to rely on solid data, and that is what we have, thanks to Matthew, and also to Professor Yarik Kryvoi and his team in the British Institute of International and Comparative Law. I always say BIICL. So we have the chance of a very solid team that has been working together for years now to produce what we have before us. And so without further ado, I'm going to give the floor to the authors of the study to walk us through their findings. And then I will give the floor to our two distinguished and highly competent discussants, Chin-Leng Lim from the Hong Kong University, and Wendy Miles from 20 Essex in London. So before anything, we will listen to Matthew and Yarik and hear more about costs, duration, and damages. Thank you very much.
Thank you very much, Anna, for the kind introduction, and indeed your strong encouragement and support of the study over many years now. It's been very good to have your support. If we could just get the slides on screen and get up to the second slide. Just in brief, how we're going to tackle this today is we're going to first have a quick look at the background and methodology for the study before looking at some of the key figures coming out of the all-time data. Yarik and I will then divide up the 8 key findings as we see them before offering some brief concluding remarks and then handing over to the discussants. So as to sort of background and methodology, as Anna said, this is the third iteration of the study, the first having been 2013, a follow-up in 2017. At that point, as Allen Overy studies, we originally had 200 cases in the first pool of data, 324 by the 2017 study. This year, we're delighted to partner up with Yarik and his team at BIICL and have added another 140 awards to that data pool, taking us to I think 434 costs awards and 775 annulment decisions. As to the detailed methodology, that will be found in the paper itself, which will be published later this month. A short summary of the key findings will be circulated shortly after this presentation today, but the full report will follow. And then just a brief word on definitions. We'll refer to party costs and tribunal costs today. By party costs, we mean all legal costs and expenses of parties' attorneys, as well as expert costs and expenses and costs of witnesses, including travel, etc. By tribunal costs, we mean tribunal fees and expenses and any institutional fees which may apply. So moving to the next slide, we have the key all-time data. We include both mean and median figures. As you see, there's quite a significant difference between them. There is a substantial upward skewing effect from some of the largest claims. And so you see the mean investor costs, for instance, at 6.4 million for the all-time data versus a median of 3.8 million. So arguably the median figure gives a typical investor with a medium-sized, medium complexity claim a better idea of what the likely costs might be. Consistent with previous versions of the studies, we see that investors continue to incur significantly greater party costs than respondent states. The difference is over 25%, whether you look at the mean or the median amounts. The likely reasons for that, I think, are probably that the investor, of course, bears the burden of proof of their claims and has to do more of the running evidentially. And there's, of course, a tendency for respondent states to run tenders to allocate the legal work, which are often cost-driven processes. But it is a notable difference which remains between 6.4 million for the mean investor versus mean state costs of 4.7 million. In terms of costs which are awarded to the successful party, the mean amount awarded to date is $3.5 million US. That mean amount has increased by more than $1 million over the past 3 years. You can see that from the gap between the figures actually awarded and those incurred, that it is still quite rare for successful parties to recover the full amount of costs they have incurred in proceedings. Typically, the tribunal applies a discount to those amounts. As to the length of proceedings, by which we mean the length from filing of the request for arbitration or the notice of arbitration context of UNCITRAL claims through to the final award, we see that the mean length is now 4.4 years. That's risen slightly in the past few years, as we shall see. The median length, however, somewhat lower at 3.8 years. And again, you see a skewing effect from some of the longest cases. I think the longest running investment treaty saga remains the Victor Pay Casado and Chile matter, which commenced back in 1998 with an RFA. There was a final award in 2008 after 3 years of challenges to arbitrators. There was then an annulment followed by a new tribunal being constituted. And finally, the second annulment decision concluded in January 2020. We move to the next slide. An interesting sort of reversal of the upward trend which was observed in the last study. So you can see with the data up to 2012, compared with the second block, 2013 to 2017, there was quite a substantial jump in party costs for both investors and claimants. No doubt that was in part driven by the fact that the 2012 study included all-time data. So in some cases looking back for many years. But what is interesting is we've seen sort of a stabilizing of those costs, at least as regards the investor, dropping slightly from 7.4 to 7.2 million mean and 4.2 to 4.1 in terms of median averages, and a more substantial drop as regards respondents, from over 5 million mean to 4.4 million, and down from 3.4 million as a median figure to 2.3 million. So quite a substantial drop as regards respondents. And that's explored further on the next slide, where we could see the drop in the median. If you look at the bottom half of the slide, you sort of see the jump up from the 2012 data to 2017, followed by the drop more recently. So it does appear to be a significant reversal. As to possible factors for that, one appears to be the increased reliance on in-house counsel by certain respondent states. For example, in the Bell'Energia case against Italy, Italy was represented by its own government counsel, and their costs were around $400,000 versus 1.8 million from the investor for a 4-year proceeding. That's in fact the lowest figure of costs incurred by respondents in the past 3 years. Spain is also known as one of the countries that has been relying on in-house counsel as well. The average, that is the mean average cost for Spain in the last 3 years has been 2.2 million US, which is less than half of the mean costs incurred by respondent states more generally. This may also be affected by the repetitive nature of some of these claims, particularly in the solar investment space, where presumably there are some efficiencies of many of the arguments overlapping. We move to the next slide, shows the third key finding. And in the 2017 study, we'd already identified a shift away from pay your own way in the practice of investment treaty tribunals towards a cost follow the event type approach. And that trend has continued. So as of 2017, there was already a slight majority of tribunals that were adjusting costs, at least to a degree. That has increased, so it's now 75% of tribunals that adjust either party costs or tribunal costs or both. The shift has been particularly marked for Oecd tribunals. It doesn't come out on the slide, but you'll see in the full report, Oecd tribunals have gone from a strong tendency not to adjust costs to falling pretty much into line with the UNCITRAL tribunal approach. The converse of that, of course, is there have been far fewer pay your own way orders. In the last 3 years, in those 25% of cases where parties were required to bear their own costs and share tribunal costs, it was generally because the tribunal found that the relative success on different issues in dispute meant that that was a fair approach, or because both parties had behaved unreasonably during proceedings, or in at least one instance, the investment treaty itself provided that each party should bear its own costs. We now break this down by the circumstances when an investor succeeds. This slide shows the propensity of investors to recover some of their costs. And we see that in the past, investment treaty tribunals were more likely to make an unadjusted cost order. There's the red, the dark grey on the slide, versus a fully adjusted cost order, which is the red on the slide. Now, in the latest data, you see it's 2/3 of tribunals which adjust both tribunal and party costs. And that is a significant development for parties because, of course, party costs make up the bulk of the costs of an investor-state arbitration. The next slide shows the situation for respondents. We see similarly an increased tendency to adjust all costs, shown by the red portion of the pie chart. In previous studies, we've noted that successful respondents were far less likely than successful investors to recover some of their costs. That difference has now narrowed significantly, but there is still notably a significant gap between respondents receiving a fully adjusted cost order of both tribunal and party costs versus investors. It's around 50% for respondents, it's around 2/3 for investors. It's not entirely clear why that is. It may be, for example, that there are cases where tribunals dismiss the claims for technical reasons such as jurisdiction or admissibility, but have seen enough of the facts that they have some sympathy for the investor and underlying mistreatment. But it's difficult to do more than speculate on that. Moving to the fourth finding, we see that as regards the cost of tribunal, those have been fairly stable in the past 3 years. In fact, roughly what one would expect in line with inflation, increases of 5 to 6% between the median and the mean. It's worth noting that around 90% of the cases that were covered by the study were under the UNCITRAL or Oecd rules. And there was no significant difference in the costs between the two. Perhaps surprisingly, given that Oecd applies a daily $3,000 cap on arbitrator fees, one might have expected there to be a more significant gap, but that does not come out of the data. The cheapest institution, according to the study, is the SEC in terms of tribunal costs. There, the SEC does apply a cap on arbitrator fees and institutional charges. There's a maximum amount chargeable by the arbitrators, and the SEC is subject to a fixed amount, which varies at different levels of amount in dispute. But it is worth noting that there is a much smaller case pool available in the context of SEC treaty cases. It's difficult to draw too firm conclusions from that. So I think at this point I hand over to Yarik. Thank you.
Thank you very much, Matthew. And let me say a few words about how BIICL was involved, got involved in it. So in July 2019, we had an event in Hong Kong because before the pandemic, and still BIICL is interested in expanding into Asia. And we met with Matthew at a social function. And I knew about their study already. And I thought that more could be done on those topics. Certain additional questions could be raised. And so I tried to persuade him to do the next iteration of the study jointly. And I managed to do that. And then we started to work on this. So as usual, usually the most difficult part is the data heavy lifting. You need to put all cases on one place first, then you need to put these cases into a spreadsheet. And we really benefited from from Matthew's team involvement in it, Dan Hrtska and Timothy Tai was involved at the very last end. So I'm very grateful to the members of the Allen and Overy team for making it happen. So this version of the study, you will see it will be different from previous versions. It will have much more infographics. We will discuss a number of additional questions. So it will be an expanded version, and we cannot cover the full study during this short event, because I think the study is around 40 pages with multiple graphs and tables. But here we wanted to highlight just some points, and I will focus on 3 findings. The first finding relates to costs of annulment proceedings. So our research suggests that the costs of annulment proceedings have actually increased. So unlike costs of normal proceedings, annulment proceedings are becoming more expensive. And if you look at this table, you will see that prior to June 2017, there were just 19 annulment decisions, and between 1917 and 2020, there were 21. So there is an increase in the number of annulment proceedings, and the annulment proceedings have also become more expensive. Not by a huge amount, but still there is a significant difference between the pre-2017 and post-2017 decisions, rather not decisions reflecting costs. And the costs themselves have also slightly increased. You can see that the mean figure pre-2017 was 0.44 million, and now it's 0.46 million. If we go to the next slide, this slide reflects the attitudes of ad hoc annulment committees to adjusting costs. We noted in our previous slides that overall tribunals are more likely to adjust costs. In other words, to follow the principle that the costs follow the event, rather than split them, rather than each party carries its own costs. And if we look at the drafting history of the Exit Convention, actually they were tempted by the ICJ approach, because it looked to them like a more public adjudication, and then each party should bear its own costs. But with normal, with arbitration committees, with arbitration tribunals, they tend to like the costs follow the event approach more. It doesn't happen in case of annulment proceedings, and not only. The cost of annulment proceedings have increased, and annulment committees are more likely to adjust costs than 3 years ago. But overall, you see that they are less likely compared to normal proceedings to adjust costs. If we move to the next slide, here we can see that investors should expect a significant haircut on the amount they claim. In other words, if investors claim a very high amount, then tribunals almost never award this amount. And these two figures show that in the past, the discount was 62%, and so now it's the discount is also there. And if we look at the next slide, we will see that this discount actually depends on the amount in dispute. So the most haircut, or the highest discount, is expected at the highest claims. So if the damages claimed are over 1 billion, then the discount is 5%. If the damages are less, let's say between 50 and 100 million, then the discount is less, and parties get 44% of what they claim. And if it's over 1 billion, then they get only 5% of what they claim. So in other words, the discount is 95% versus 56%. And there can be different reasons explaining why tribunals are not willing to award the full amounts of damages requested. One reason could be that they do not feel comfortable in awarding to private investors very large amounts against states, because politically that will not look appropriate. Also, investors may tend to overvalue their claims in high value disputes. And that may also, tribunals may also be conscious of that and give this, significantly discount the amounts which are requested. Now, you can also see that the costs awarded have increased, so are increasing. The higher the amount requested, the higher the costs awarded to the claimants. So you can see from, let's say, if the claim is below 50 million, then the amount of costs awarded is 0.57. If the claims are over 1 billion, then the costs are also higher, 1.8 million. And in the final version of the study, you will also see a chart showing how that there are different, there are also outliers. So it's possible to have to get a large award in your favor, but have very small legal costs. But usually the costs correlate. So the more complex the case, the higher the stakes, the more parties have to pay for their in legal fees and in tribunals fees and so on. So now let me move to the next slide, which deals with duration of investor-state cases. So here we can see that before June 2017, the mean duration was 4 years and the median duration was 3.7 years. Over the last 3 years, to be more precise, between 2017 and 2020, the number of years has increased. So now the mean duration is 5.5 years and the median duration is 4.1 years. And we can't come up with a simple theory explaining why the duration is getting longer, particularly given the fact that the costs are usually getting lower. And perhaps we have now more repeat players on the market. So let's say states who faced multiple claims against them, and they know how to delay if they want the proceedings, and at the same time they know how to make their costs more efficient. So we can only speculate that, but what we know for sure is that the duration of investor-state disputes has been increasing over the last 3 years. If we move to the next slide, please. Here we compared duration of investor-state disputes under different rules. So if you look at UNCITRAL and UNCITRAL rules, then they are very similar. And well, UNCITRAL just slightly, well, the median UNCITRAL figure is slightly smaller than the median UNCITRAL figure, but the mean UNCITRAL figure is slightly higher. So there is no significant difference. If we look, however, at SCC and ICC, the Stockholm Chamber of Commerce and International Chamber of Commerce, they tend to have shorter proceedings. And it's difficult to say why this is the case. It could be that because normally private arbitration, private adjudication is quicker compared to public adjudication. But it could also be because the number of cases which were decided by under ICC rules and SCC rules, the number of investor-state cases is not particularly high. So it could be that if the number is growing, then we will also see that the figures under UNCITRAL exit rules will be similar to SCC and ICC rules. But at the moment, the SCC and ICC rules offer slightly quicker proceedings. Now, if we move to the next slide, this slide shows our finding on bifurcation of proceedings. So bifurcation do not usually result in early termination of proceedings. And we also noted that that on average, bifurcated proceedings last longer than proceedings which are not bifurcated. And however, in some cases, bifurcated proceedings lead to early dismissal of cases. For example, I think we do have one more slide there, slide 9. Oh, sorry, the next slide. Oh, yeah, sorry. Okay, then it's just in my notes. So the number of bifurcated proceedings after 2017 was 29, and of those, 7 were bifurcated because the tribunal wanted to bifurcate the merit stage and the quantum stage, but the large majority of those cases actually dealt with bifurcation of jurisdictional issues. So tribunals first look at jurisdiction, and then they decide on the merits in a sort of as a separate stage. Why are bifurcated proceedings usually longer? Well, while one explanation, one plausible explanation could be that usually bifurcated proceedings are more complicated. So you have many more issues involved. You have quantitative issues, you have jurisdictional issues, and as a result, tribunals tend to treat them slightly differently, and they want to bifurcate them for the reason of their complexity. And complex disputes usually take longer. While if you have a simple dispute, you are not going to bifurcate it. So as a result, it will last less, and it will also cost you less. So that means that bifurcation is not necessarily an automatic way to make your proceedings longer and more costly, but it's just because bifurcated proceedings are usually more costly. So let me thank you here for your attention, and now we are going to hear our discussants, right, Anna?
Absolutely. Thank you very much. Again, I have been taking notes feverishly, and I hope to have the opportunity to grill you a little bit later, if time permits. But since we are very much on time, I will now go straight to our discussants. And I will start with giving the floor to Xin Leng Lim, who will give us his comments, views, and his reading of some of the findings that you have in your study. Xin, you have the floor.
Thanks very much, Anna. And congratulations to Daniel, Yarik, and of course to Matthew for this latest Hodgson report. I want to go back, if I may, to what Anna was saying earlier about the importance of this study for the current debate on ISDS reform. And maybe the best way to approach this is for me to come up with a very simple or simplified statement at the outset. If what we are seeing is that the cost figures are going down, if I can put it that way, but damages awards are going up, then that could have implications in the way that we are currently looking at ISDS reform in Working Group 3. I'll just focus on 3 points: cost and duration, damages, and the apparent indifference, if I read this report or the draft report correctly, the apparent indifference of cost and duration to one's choice of arbitration rules. Doesn't really matter which set of rules you choose. In the context of Working Group 3, as Anna said, the focus is on cost and duration. It's on jurisprudential incoherence or the lack of a system of binding precedent. And it is on the arbitrator appointments process. But cost and duration are viewed through the lenses of jurisprudential incoherence and the arbitrator appointment system, because there is this sense that the reason costs are high, the reason proceedings take a considerable amount of time when you compare it to commercial arbitration is because of the incoherent state, it is said, of investment arbitration jurisprudence. And it is because of the kinds of delays that we get because we have this arbitrator appointment process. And if I may say so, I think this sort of discussion came to a head just last week, where some people asked, well, where does assessment of damages and calculation of interest come in if we're going to focus on cost and duration, jurisprudential incoherence, and arbitrator appointment? And so there seems to be this perception gap between the relative importance of costs and large damages. And if I recall correctly, one delegation, and of course I shouldn't name which delegation it was, said, if I remember correctly, that we needed guidance on damages and on calculation of interest, similar to the way that we would need a code of conduct for arbitrators. And that gives us some food for thought. What kind of guidance are we talking about here, where treaties might even stipulate that interest is to be at a commercial rate, usually taken to mean compound interest? Are we going to go into these kinds of issues? Are we going to go into DCF, DELC? But putting that aside, we'll just have to see how things proceed from here. Let me come to my first point, which is cost and duration. What we're seeing is that arbitration proceedings are becoming cheaper, particularly taking the median figures. We see a fall of 32% for respondents, and that seems to be the big finding in this report. At the same time, claimant costs are higher and proceedings are taking longer. I think one of the figures we've seen is 5.5 years. And what Matthew said just now was one possibility is that there is greater use of in-house counsel on the part of respondents. It may be due to the repetitive nature of these, some of these cases, and I think he cited Spain as an example. One shouldn't speculate too much, but in the WG3 context, one thing I noticed, and I think it was in the report of the 36th session, is a focus on the possible structural imbalance that may have arisen from the introduction of third-party funding. I'm not asking the authors to speculate on that. I'm asking this question of myself. Is this disparity between how much claimants spend and how much respondents are spending possibly related to the availability of third-party funding? Because the gap now, we see, one of the figures we see is a gap of 1.8 million, with the difference doubling between the claimant and the respondent in the last 3 years. So if I were mischievous, I wouldn't ask, well, what's the cause? I might ask, where's the money coming from? So that's cost and duration. On damages, we see a significant upward trend. We see claimants being awarded larger amounts, and I think it's at page 15 of the draft report that we see some startling numbers, where even if UCOS were discounted, if we take the mean figure, the increase is, I think, something like 47%. Sure, they're getting a haircut, and that was mentioned in the sense that what claimants are claiming they're not getting. In fact, they're getting significantly less. But overall, when we look at the figures, if I understand this correctly, they are claiming more overall, and they are getting more overall, if that's what page 17 really is about. And they're doing all this over a longer period. So cost and duration issues are real. I'm not trying to say that they're not. They seem to be indifferent, and this is my final point, to what set of arbitration rules we choose, or that's what the report suggests. We know, however, that some issues can be addressed in reforming procedural rules, and the report mentions SCC's cost-saving measures, but arbitrator costs, that's not the bulk of it. The way the reform debate deals with it, WG3 seems to draw the line somewhere else between issues that are within party control and issues that are outside party control. So it's within party control to choose whatever arbitration rules they want, but that doesn't seem to make a difference. The argument is that it's the factors outside party control which drives the need, or so it is argued, for systemic reform. And that is due to a lack of a system of binding precedent, because we're spending a lot of time arguing over the same points of law where the points can go either way, and through delays in the tribunal appointment process. So just to sum up, what I have focused on looking at the draft report is the imbalance between claimant and respondent costs, the apparent disjuncture between cost figures going down, damages figures going up, and it has prompted me to think about the factors that are at play here. I should stop there because I've only been given 15 minutes. Thank you very much. Thank you.
Thank you very much for your comments, dear Shin. And thank you for also drawing on the recent discussions in Working Group 3, where indeed the issue of damages and damages calculation standards and how to recalibrate or bring this back to some kind of reality has really been raised forcefully and interestingly. And I can say that you didn't want to name the delegation, but I could say that this came mostly from African countries that have been making a very strong case that we need to put the study of reform on damages high on the agenda of the working group. So thanks for that. Without further ado, I'm giving the floor to my dear friend, Wendy.
Thank you so much, Anna, and thank you, Chen. That was fascinating. I wish you had have kept going. So congratulations, Matthew and Yarik, Allen Overy and BIICL. I've been fascinated by this report since it was first published at the end of 2012. It's a subject that's dear to my heart. I think that makes me a costs bore, but we ran a similar analysis on costs back at the time that Matthew was publishing this report, and then got much deeper into it. Folks might recall the 2015 ICC report on cost allocation and commercial arbitration. And so I actually really like this topic, and I think this is an incredibly valuable report and genuinely look forward to its quinquennial publications. So I recognize how much work goes into an enterprise like this, and I'm glad that Allen Overy is being quarterbacked by the academics at BIICL, and I think that's wonderful. I know how valuable this is to users, and I urge people, when you get the report, to take some downtime and give it a close read, give it a couple of reads. It has incredibly valuable information, and I mean that literally. It will add to your profit bottom line if you read and understand this material. And the 70 odd of you who are here today will, as a result, have a competitive advantage. So the real beauty in this report is it's tracked data and trends in real time. Matthew's done this for a decade now. He's actually tracked it in these 3 study periods over the course of the decade. And it's this latest 3rd study period and report has produced some really exciting findings. So I'd like to just talk about a couple of them that jumped out at me, and hopefully try and link back to some of the policy level things that Chin talked about. So the first key finding that I want to talk about is key finding 3. The prospects of recovering costs have improved. And to me, this is actually the single most important finding in the report, but maybe that just reveals my personal interest. I think it's dramatic, and you've seen the statistics, right? They're in the report. Matthew put them up in his presentation. But in the first study period, which is all cases up to 2012 across institutions in investor state arbitration, 56% of parties bore their own costs. So clearly, more often than not, there was no costs award. And then in the second study period, that dropped by almost a third. So 36% of parties bore their own costs, so didn't get a costs award. That's from 2012 to 2017. But then what this report tells us is that's now dropped by another third to 23%. It's only 23% of cases where there's no cost adjustment and investment treaty arbitration. So that means 77% of cases have some cost shifting. So those two consecutive drops of 30% in those quinquennial periods, that's huge. And it matters because in commercial arbitration, by comparison, by around 2012, that first period when those costs were 56% of cases not shifting, by comparison in commercial arbitration, 90% of cases costs were shifting, some cost shifting in favor of the prevailing party. So it's 90% in commercial was shifting and only 44% in treaty was shifting, right? So your 56% chance you won't get any costs in investor state, 10% chance you won't get any costs in commercial. That was the first study period. But you compare that to where we are now, and that gap is really, really closing. So it does raise two questions. Why were those periods in the investor state arbitration, why were those numbers so different across the periods? And why are they coming more closely aligned today? And the report actually goes some way to answering that, although it's purely quantitative. It's the empirical analysis, as Anna says, and this is what's so powerful about this report. It's policy neutral. It doesn't make any judgments. It just gives you the stats and the numbers and the facts. And some of the facts it gives you, it sets out in the first part, the rules, the different rules on costs. And the UNCITRAL Convention at Article 61.1.2, as you know, is costs neutral, right? It leaves it to the tribunal to decide what to do about costs. It's not a presumption of cost shifting or a presumption of costs lying where they fall. And we know, because the report has gone through the Tribunal and reminded us that the original proposal at UNCITRAL was that costs would lie where they fall, because that's what typically happens in state-to-state arbitration and public international law. But in the negotiations that shifted, and I've been back through the Tribunal on this a few years back, and it turns out that the states that proposed that were not common law states. It was Brazil and Austria that raised that. And Brazil and Austria said, and you can read the Tribunal, they said, but we have costs following the event, so it's very normal for us. But I don't think Brazil and Austria were contemplating English common law style costs follow the event. I think they were contemplating much more of a fixed cost, sort of national state court style. So there's a case of careful what you ask for. Now, the UNCITRAL 1976 rules, as the report says, traditionally had the same approach. Policy neutral, cost neutral, allocation neutral, do what you want. But the 2010 rules, again, as the report tells us, changed all that. It was the 2010 UNCITRAL rules that introduced a cost follow the event presumption. Okay, so I've often wondered whether this change was driven by commercial arbitration norms, because of course UNCITRAL rules are used in so much ad hoc commercial arbitration. And I've often wondered if it had unintended consequences for investor state costs awards. And that then created a misalignment with the typical PIL claims. So UNCITRAL is going through its proposed rule changes right now and should be thinking hard about this, because the breakdown of the UNCITRAL and UNCITRAL cost allocation per institution in the report show us that there is a differential. In the whole period, so across all lifetime, 3 study periods, 49% of UNCITRAL cases, no adjustment. but only 28% of UNCITRAL cases, no adjustment. So big difference, right? And then we know as we get into the data that Matthew and his team have provided, that if you break down the study periods, that 2010 rule change appears to signal a shift in that trend. And the trend is moving quicker in UNCITRAL. Although it is catching up, UNCITRAL is clearly influenced by that change in the UNCITRAL rules. So as states are involved in the UNCITRAL rules revision, they may do well to pay attention to the finding in the report that costs awards, when they are made, are disproportionately made in favor of the investor. So if the state wins, still 47% of the time there is no cost shifting. Well, that's across all time, not still, across all time. If the investor wins, 37% of the time there is no cost shifting. So flip that on the head. The state will recover if it wins 53% of the time, but the investor will recover if it wins 63% of the time. So cost recovery shows us that in the differential across that last period, what the study tells us is that the number of times, or the percentage times, that investors recover their costs has increased in the recent study period by over 100%. So they're recovering costs twice as often. Compare that to respondent states, they're only recovering their costs 44% more often. So I think all of this should be informing where that policy debate's going. And then that takes us to the key finding 2 in the report, which is also fascinating, and that's the cost differential between investors and states. Respondent state, both are decreasing, but as Matthew pointed out, respondent states' costs are decreasing more rapidly. And I find that fascinating, and we'll have to wait another 5 years to see if this 2012 to 2017 spike in costs was the anomaly, or whether the 2017 to 21 drop is the anomaly. We don't know that yet. So Matthew, keep going, and Yarik. But what should be reassuring is that costs are decreasing disproportionately for states, but their win rate is pretty much unchanged. So the old get what you pay for may not be quite right. So repeat users, and Yarik explored a little bit why those costs may be decreasing, and we're seeing repeat user states tending to use in-house teams, the Attorney General's offices, Attorneys General offices, and perhaps 1 or 2 external public international law experts a bit more often, or a few key firms that specialize in this work, and judging from these figures have negotiated fairly favorable rates for those states. So the next point I wanted to come to is one that Yarik touched upon briefly, which is the correlation between damages awarded and the costs spent. And he touched on this, and there's a fascinating scatter diagram in the report. It's at page 18 for when you get your report. And what that shows us is that more fees do not necessarily mean more return. So I've never quite personally bought into the ad valorem structure of remunerating arbitrators. And I'm not convinced that a bigger claim number necessarily correlates to more required lawyer or indeed arbitrator hours. But for the party financing those lawyers, and indeed those arbitrators, be that the investor itself, the claimant, or the law firm on some form of AFA, or a third-party funder, I accept that the more that's at stake, the more you can recover, the more you may be prepared to invest. And that's indeed how third-party funding works. And a similar risk analysis applies if you're the defending state. The more you could lose, the more you might invest to protect yourself. But should that be how counsel or arbitrator hours work? And even if it is, should that be the basis upon which costs are awarded? So looking at in the round and looking at some of the numbers on damages and recovery and costs and recovery that Yarik talked about. Something that's quite interesting here for investors is considering whether investor state arbitration is worth the return on investment. Longer hearings, less money, no one's winning from that, including the arbitrators. What's causing that? Is it just dead time? So talk about return on investment, the third-party funding model. Now, this isn't my model, it's just a generic model that's out there, but on average, and I think we've got some third-party funders here, so they might correct me if I'm wrong, but I understand that on average, third-party funding return on investment model looks something like this. Probability of success, about 50%. And these figures show us, I think they put it about 47, 48%, so around there. Funders tend to receive around 25 to 35% of potential benefits of the damages, plus recovery of legal costs. So if a funder finances 10 cases with a cost of £100,000 each, total investment of £1 million, then a reasonable recovery on those numbers would be 1.75 million to 2.25 million. So assuming a duration as we have, 2 to 4 years per case, the annual expected gross return for the investor is between 15 and 50%. Now, those sorts of numbers actually align with all of the numbers in this report. So this is why I think this is so deeply and literally valuable to people who invest in investor-state arbitration. But then there's reality. Not a single funder funds all claims. The sample size here is limited, and the outliers skew the numbers, even with the adjustment by using the median and by carving out cases like UCOS. And you can see as a funder a deep negative return if you back a bunch of losing cases. Award doesn't mean recovery. Recovery is a whole nother stage. And more than once, we've witnessed a cluster of claims or damages awards against a single state. And that both increases the odds of winning if it's the same issue that comes up and is successful. But depending on the state, that might correspondingly decrease the odds of recovery. So one can't help but wonder if the cost spike we saw in the second study period from 2013 to 2017 might reflect a ramping up of third-party investment in investor-state arbitration at that time, but now we're seeing a leveling off as the appetite is diminishing. So last thing to say, page 22 of the report at the end, it refers, there's a reference to tribunal discomfort in making very large awards. And that comment gave me a little bit of discomfort. I had two immediate reactions, one of which might be right, the other is completely wrong. So my first reaction was that tribunals might be responding to a sense that claimants are exaggerating their claims. So claimants creating a form of anchoring bias, which is what we see in positional bargaining and negotiation. Now, it might be worth claimants, their lawyers, and perhaps most importantly, their damages experts at their point, thinking about whether or not that approach is having a systemic effect to their detriment and reinforcing that arbitrator discomfort and reluctance to award high damages. I don't know if that's right or not, but some quantitative analysis on it might be really interesting. So my second reaction, the one that was wrong, was one of concern. If arbitrators now are showing discomfort with large awards, what are they going to be doing in 5, 10, 15 years' time when the investments are getting bigger and the losses are getting bigger? How are they going to keep up? And then I checked whether that assumption that the investments and the losses are going to get bigger was right. And I looked at the OECD statistical data for foreign direct investment as it tracked from 2005 to 2015. And it's been on a steady decline since 2007, even before COVID hit. Yeah. FDI is coming down. So I can't help but wonder, if FDI is consistently falling, why are we seeing such high growth in claims values? 53% increase in claims values in the last 5-year period. and that's excluding UCOS from that comparison to that number. So let me stop there, but I could go on forever because I really do love this report, and I thank you all for making my week and giving me an opportunity to have a preview.
Thank you very much, Wendy, for your comments, insights, and very interesting analysis. And thank you, Shin, as well, for doing something that the report very knowingly does not do, which is find explanations. And that's what one of the things that I particularly like about this Allen and Overy and BIICL report is that it is factual, it's data, and you do not venture into explanations and policy implications, and you leave that to us. And I'm very grateful for this opportunity to now open the floor and discuss with all the participants and take your questions and open a debate. It's always difficult to do it online, but I think with we are all becoming more knowledgeable about Zoom conferencing. So I would suggest that whoever would like to take the floor